addendum or an amendment that you could do to this agreement. So let's just say, while we're on this subject, you're not under contract and your agreement expires at the end of this month and you want to continue working with the buyers and you just haven't found them anything yet. Just go get them to sign a new agreement that starts May 1st, right? So you just go from one agreement right into the next one because we don't really have an amendment type of thing right now. So the buyer is interested in acquiring real property as follows, or is otherwise acceptable to the buyer. So the type of property, now the type of property, location, price range, you kind of fill in this information with what you know in your conversation with the buyer. But here's what I will tell you, and there are several spots in the Code of Ethics under Article 16 that discuss this. And so I'm just going to kind of paraphrase here what could happen. A buyer can be under multiple exclusive buyer brokerage agreements at the same time. And there's nothing wrong with that. But let me clarify. What if the buyer wants to purchase a property in Tampa and Jacksonville and Titusville all at the same time? So maybe they're coming into Florida and they're looking at buying investment properties or vacation rentals or whatever, right? In all those different areas. They could have agreements with realtors in each of those areas that does not conflict with the other because you probably work in your specific area. So when you think about that and you look at your location, do not put Florida if you do not cover all of Florida and you don't cover all of Florida well, right? And if you do, I'll refer you back to the Code of Ethics because there's some requirements for that, right? Of knowing your market area and having access to the information and, being able to provide that and so on. There's some requirements in the Code of Ethics for that, or coverage areas. But I would also tell you the same thing with the type of property. They could have two agreements in the same city. So let's say that they're in Tampa and one agreement is to buy let's say an investment property, a duplex or a triplex is what they're looking for to rent out and make money off of. But they also have hired someone to find them their luxury waterfront property that they want to live in. And they want a waterfront specialist to help them with that. Well, those are two completely different markets, and that might be two different realtors assisting them with that, even though it's in the same geographical market. So that's okay, as long as those agreements don't conflict. And the Code of Ethics says that's okay. So we're not to put them in agreements that conflict, but we want to make sure that we also don't limit them to where they can't go hire someone for services to protect them, because it's always about protecting the consumer first, right? It's always about the buyer's best interest first. So you just want to be careful. So when you talk about type of property, what's your market? What are you being hired to help them with? Location, what's your market? If you don't have access to information to show them property and help them throughout all of Florida, do not put Florida on there, right? Make sure you're very specific with that. And then again, price ranges if they've been pre-qualified or pre-approved. And then if they have preferred terms and conditions, like if they they must have, down payment assistance or, the seller assists with closing costs, things like that. You might want to fill that in. So then we go to the broker's assistance. So the broker will use their professional knowledge and skills, assist the buyer in determining their financial capabilities and financing options, discuss property requirements and assist the buyer in locating and viewing suitable properties, assist the buyer to contract for property, monitor deadlines and close any resulting transaction, cooperate with real estate licensees working with the seller, if any, to effect a transaction. And the buyer understands that even if the broker is compensated by a seller or a real estate licensee who's working with that seller, that compensation does not compromise the broker's duties to the buyer because our representation is separate, right? We don't have dual agency or sub-agency, I should say, either of those. So other buyers, it's the same disclosure that we could be working with other buyers. And if they make an offer, we'll disclose that, but not the terms of the offer. Fair housing is the same disclosure. Service providers is the same disclosure. Okay. So the buyer obligations, the buyer agrees to cooperate with the broker in accomplishing the objectives of this agreement, including conducting all negotiations and efforts to locate suitable property only through the broker, and referring to the broker all inquiries of any kind from real estate licensees, property owners, or any other source. If the buyer contacts or is contacted by a seller or real estate licensee who's working with a seller, or views a property unaccompanied by the broker, buyer will at first opportunity advise the seller or real estate licensee that they're working with and represented exclusively by the broker. Okay. So make sure you tell them, hey, here's a bunch of my business cards. This is what you need when you're working with me, right? And I call them admission tickets. Like if they're going to go to an open house, if they're going to go to a builder, if they're, whatever, here's your admission ticket. Providing the broker with accurate personal and financial information requested. And there again, that buyer authorizes the broker to run a credit check. We've already talked about how to handle that though. Being available to meet. I'm sorry.
I am going to just kind of peek in just a little bit. We are due for a break.
I know. I was sorry. I was just going to finish this one section.
Nope, that's okay. Finish super fast and then we're going to go on break.
Okay. Being available to meet with the broker at reasonable times to consultations and to view property, indemnify and hold the broker harmless, not asking or expecting us to restrict based on fair housing, and consulting for appropriate professionals on that legal, tax, environmental, so on. Okay. And then before we get into the money part, we're taking a break. Nikki, I'm gonna turn it over to you.
Thank you so much. I know we were going through a lot of things. Once again, thank you so much for being patient with the questions and answers. I promise we are doing as much as we can. But please do keep in mind that Cynthia will not be able to share every opinion on every scenario that we are getting within this class time. So thank you so much for your understanding. We have a 10-minute break. Do not log out or go anywhere. We'll see you in 10 minutes. All right, y'all, as we do come back, I did just want to give you a little bit of notice. So as we come back from break, thank you so much for your patience. Thank you so much for your understanding. Just to give you a little bit of insight, we have over 600 questions. We are only a few of us, and I am doing my absolute best to summarize and keep up with everything. But please do keep in mind, Cynthia is one person and is not able to share her opinion on every single situation and scenario. Once again, a shout out to our legal hotline for any of your very specific questions. And please do keep in mind that the class has a finite amount of time. Cynthia has information she has to get through. And so if your question is not answered, once again, the legal hotline is a wonderful reference, as well as NAR's website and our education that we do have available. So thank you again for your understanding. And Cynthia, I'm going to hand it on over.
Thank you. Thank you, Nikki. Okay, so here's what we're going to do to wrap up this last hour. We're going to finish through this agreement. I'm going to answer. You have some great questions in there. I'm going to answer as many of them as I can. And there are a couple of things that correlate with the Code of Ethics. So I'm going to show you that as well. Because as I promised, there's a lot of things in the Code of Ethics that changes once you are engaged and you have that signed buyer broker agreement. All right, so let's talk about the money here and the retainer section, number 6. So upon final execution of this agreement, the buyer will pay the broker a non-refundable retainer fee. So I'm going to pause here for a moment. If it's non-refundable as a fee, it is not escrow. This is not considered earnest money deposit or escrow money. It's a non-refundable fee, okay? Of blank dollars, whatever that is, go talk to your broker if you charge that and how much. For the broker's services. This fee is not refundable and will or will not be credited to the buyer if compensation is earned by the broker as specified in this agreement. Okay, a retainer. Let me just tell you how this would work if you charge one, and it will be credited to the buyer if compensation is earned. It shows up on the closing statement as the amount that they've already paid, but paid outside of closing, POC. Very similar to how the buyer pays the appraisal, but the appraisal fee still shows up on the closing statement and it says paid outside of closing. It's a very similar process. They still disclose and show the money, but they show it has already been paid outside of closing. That's if they're going to be credited with the money. Now, I can't talk to you about, retainers and how much and whatnot, but I'll give you a couple of scenarios, okay? Let's say that you have a buyer that comes to you that wants you to do a specific mailer to a specific area to find them a specific property. That's going to cost you a lot of money up front. Well, maybe that would be an ideal situation for a retainer if you know that it's going to cost you money and you want them to participate in helping you for that upfront cost or something along those lines. I think we all know what a retainer is when we think about an attorney relationship or so on. So again, go back and seek that guidance with your broker of what and how that works within your company. Okay. All right. Now, compensation. Broker's compensation is earned when during the term of this agreement or any renewal or extension, the buyer or any person acting for or on behalf of the buyer contracts to acquire real property as specified in this agreement. The buyer will be responsible for paying the broker the amount specified below, okay? But will be credited with any amount which the broker receives from a seller or a real estate licensee who is working with a seller. So just to be clear, a builder is the seller, right? The real estate licensee, that's the broker, is the listing licensee. Even if they're working with the seller, if they're paying you compensation or commission, that's the licensee or the brokerage, right? So we're, of course, going to seek that outside compensation first, but the buyer is ultimately responsible for paying this amount of money, whatever this is that we've agreed to, this compensation, but will be credited from any of that money we get from those outside sources, okay? So the purchase or exchange dollar amount or percentage plus a flat dollar amount of the total purchase price or other consideration for the acquired property at closing. There's a section that you can use for leases if they end up leasing a property instead of purchasing. And there's a section for options that you can fill in there. Again, you need to go back and have that conversation with your broker. What's our fee for our services? What's the compensation that we charge when working with the buyer? What do we put in here? Okay, that's a broker conversation that you have. Now, there's a couple of questions about the range. So a range might be, and again, I'm going to use my example numbers for class. If compensation is between 12 and 14%, this agreement is deemed satisfied. We don't automatically have that built into this agreement, but it is something that you could add into these special clauses. There's a blank section here at the end of the agreement. However, because of the terms of the settlement, I'm going to tell you to call the legal hotline. Because the terms of the settlement state we cannot accept more than what's in the agreement with the buyer. I don't know yet how that's going to affect range pricing with that, the range compensation field. I don't have an answer for you. I'm sorry. We just don't have clarity yet on that. And I would tell you to call the legal hotline, right, and seek guidance. Or again, we're seeking some clarity. I'm seeking some clarity from NAR on that. So. Okay, other broker will be compensated for all other types of acquisitions as if such acquisition were a purchase or exchange. And then the buyer default, the buyer will pay the broker's compensation immediately upon the buyer's default on any contract to acquire the property. So some of these are very similar to what we see in the listing agreement. All right, the protection period, also we have this in the listing agreement that the buyer will pay the broker's compensation if within so many days after the termination date, the buyer contracts to acquire any property which was called to the buyer's attention by the broker or any other person or found by the buyer during the term of this agreement. Buyer's obligation to pay the broker's fees ceases upon the buyer entering into a good faith exclusive buyer brokerage agreement with another broker after the termination date. If they want to go hire somebody else, that's acceptable. And that, again, mirror images what's in the listing agreement. Now, early termination, this is if they want to fire us early, quite frankly. The buyer may terminate this agreement at any time by written notice to the broker, but will remain responsible for paying the broker's compensation if from the early termination date to the termination date, plus whatever that protection period is that you filled in paragraph 8, okay? If the buyer contracts to acquire any property which prior to the early termination date, before they canceled, was found by the buyer or called to the buyer's attention by the buyer or any other person. The broker may terminate this agreement at any time, though, by written notice to the buyer. So if the broker does that, the buyer, though, gets fully released from all further obligations under this agreement. So if the broker cancels, the buyer's gone, they can do what they want. If the buyer cancels, they're still on the hook for anything that we would consider, let's just say, procuring cause, right, that we showed them or told them about prior to that. Okay. Dispute resolution is the same. It's mediation, and then it goes to arbitration. The broker may assign this agreement to another broker. Companies merge, sell, whatever. This agreement will bind and inure to brokers and buyers' heirs, personal representatives, successors, and assigns. And then the brokerage relationship. Now, this particular form is the transaction broker form because that's what we're all presumed. But again, go pull the one for single agency. There's a transition from single agency to transaction brokerage, and there is a no brokerage relationship one. So you are welcome to pull any of those. So it just has the brokerage disclosure for the brokerage relationship disclosure for transaction broker. All right, special clauses. So this is that section that has some blanks in there that you may or may not use for something. And then again, the buyers sign, real estate associate and real estate broker, which is similar to the showing agreement that we had talked about before. Okay. All right. We have lots of questions. I want to get to a few of these, and I'm going to change the screen because I have a few things here in the Code of Ethics I want to refer to. So, okay. The ranges I talked about, I'm not sure about that. Okay. Bonuses. So the bonuses, let's say from the builder, which I'd mentioned before, any type of overage in the settlement, we're not allowed to accept. So basically, we can give that back to the buyer. They can negotiate that in the terms. Can it also be part of the closing cost? Can it be, credited back to the buyer's closing costs? Yes, that's another possibility that it could be. So basically, new construction, it's not that it can't be accepted. We cannot accept it. So if the builder is offering, let's just say 14%, and our agreement says 12%, we have to figure out how to get that 2% to the buyer, right? That really is what happens, or negotiated in their deal. So again, the builder may not be willing to reduce the sales price based off of it. So do they buy down their rate? Do they use it for closing cost? Do they use it for upgrades, or again, a refrigerator or a washer dryer or other things like that that they could build into the deal, right? Those are things that they could do that's acceptable, as part of that, as long as it's fully disclosed to everyone. Okay, this question. Thank you for this question. Does the buyer rep agreement need to be disclosed to anyone other than the buyer? Obviously. Okay, let's look at standard practice 1610. Realtors acting as buyer representatives or brokers shall disclose that relationship to the seller's representative or broker at first contact, and shall provide written confirmation of that disclosure to the seller representative or broker not later than the execution of a purchase agreement or lease. So yes, you must disclose that you're in an exclusive agreement with a buyer. So typically how I've done this is I pick up the phone and call, and let's say I'm making a showing appointment and I'm actually going to talk to the agent. Remember those days? We're about to get back to that. And so I pick up the phone and call the agent and say, hey, I'm a buyer's rep for my buyer, and I'd like to make an appointment at, this property. Or I exclusively represent my buyer, and I'd like to make an appointment to show your property. I've now made that verbal disclosure, right? You can do it in any fashion as long as you get it across to them. But then it says you shall provide written confirmation of that disclosure later. Okay. Now, there's nothing that says you have to actually provide your exclusive buyer brokerage agreement. You don't have to actually give a copy of the agreement to the seller or to the agent. There's nothing that says that. So you don't have to give the agreement, but you have to give some kind of written confirmation of that disclosure. Could that be an email? That's written confirmation that just says, hey, thanks for the showing. My buyers have made an offer. It's attached. And I also just wanted to let you know, I represent in an exclusive fashion my buyer with an exclusive buyer brokerage agreement or something like that. Now, here's the scenario though. Let's say that the seller is offering $100 as that co-broke or nothing. And the buyer is obligated to pay 12%. And the buyer has put in their offer that they want the seller to pay the 12% commission to satisfy the buyer broker agreement. Now, I view this similar to like the appraisal issue. If the property doesn't appraise, the first thing the seller wants is to see the appraisal. So I think there may be sellers that say, well, if they're going to ask me to pay the 12% per the agreement, I want to see the agreement. I don't know. So they would have to negotiate that. But there's nothing anywhere that says you have to provide a copy of your agreement from one to the other. But you do have to disclose that you're acting as a buyer's rep and a confirmation disclosure, and then you have to follow that up in writing. Now, 1611 says the same thing on unlisted property. What's unlisted property? That's a first sale by owner, right? Basically. But then it follows it up with one more thing. Realtors shall make any request for anticipated compensation from the seller at first contact. So again, the last place we look for our compensation is the buyer. We're immediately going to ask the seller, hey, I'm a realtor. I exclusively represent my buyer. I'd love to hear more about your property. And by the way, will you pay my compensation? Right? And that's how the conversation's going to go. And then you just kind of take it from there, right? Okay. Do we have to call the listing agent ourselves to see if the property is offering compensation? I don't know. I really don't know. We're entering into a new phase of real estate, and I don't think we'll have a good grasp until probably October, right? I mean, think about it. We're going to have to just kind of work it in the trenches for a few months to figure out exactly how this is going to work. I think that we're going to have a lot more communication, which I'm happy about personally. I think we're going to have to communicate with each other more. I think we're going to have to, have those conversations if there's compensation offered. I think we're going to have to back that up with some communication in writing. I think we'll get it. We'll get it together. I just don't know the exact answer to your question, though. I don't know, exactly of what we're going to have to do for that, but I do imagine there'll be some of that. Now, brokerages can advertise it. There are certain things that they can do. So they can advertise it individually on their own websites and things like that. But I still think that there's going to be a lot more communication, which I'm kind of happy about. So, all right. Asking for compensation. Is that a part of the total max credits allowed for certain loan types, like with FHA, VA, and so on? Yes. So that's the other concern is that, now let me be clear. Let me rephrase that answer. Okay. Yes and no. If the buyer is writing in the offer that the seller is paying the compensation, no, they're not getting any credit from the seller for that. Now, they might pay a different purchase price or whatever they negotiate with the seller, but ultimately, if they negotiate that the seller is paying the 12%, the seller is paying that, not the buyer. That's not a part of any of their credits. But if they're asking, let's say that the seller just flat out says, I'm not paying it, but they just ask for a flat credit from the seller for their own closing cost. And they say, well, I'll just pay the compensation with that. Yes, now they're getting into the max credits that the lender is going to allow. But again, I think that's going to be close to a last resort. I think in most cases, again, we're going to ask the seller to pay for it first. So the seller pays for it is what we're going to seek. And it goes on their side of the closing statement. Only if the seller flat out refuses, it would go on the buyer's side, but not with VA. With VA, the seller must pay it. So that's also a conversation I think as a listing agent, we have to discuss with the seller if we believe their home will be attractive to a VA buyer. Hey, if you want to attract a VA buyer, let's talk about how compensation works and just have that conversation, right? Okay, explain interpreting contracts for clients. Interpret means to explain what an attorney does. I feel there's a double standard for this. Can you elaborate more? Sure. So what I mentioned before was that we are not to just send them a, and I'm going to find it and I'll show it to you. We cannot just send them an agreement and have them sign it without them understanding it or whatever. So in other words, it talks about the use of electronically, as I was talking about with the meeting, when we are electronically, here it is, standard of practice 9.2. Let me go back to that and I'll change the screen for you. So standard of practice 9.2 says, when assisting or enabling a client or customer, remember, engaged or dating, in establishing a contractual relationship, which would include that representation agreement, what we're talking about, or anything, electronically, realtors shall make reasonable efforts to explain the nature and disclose the specific terms of the contractual relationship being established prior to it being agreed to by a contracting party. And so, as I paraphrased, you don't just want to slip them in the agreement and say, here, sign this. This is a mistake that a lot of agents have made in the past, or realtors, where they would sit down with the buyer, have the buyer sign their offer, and at the same time they're signing the offer, they would slip in the exclusive buyer broker agreement, have them sign that at the same time. That is not the way to do it. They have to understand, and it says there you have to explain what this agreement is. So hopefully that helps with the elaboration there. So, okay, if the buyer doesn't want to pay, if the overages and bonuses exist and you won't be able to take them, can you refuse the showings of these properties? Okay, so let me just kind of clarify because these are kind of two different angles. If the buyer doesn't, no, let me start with the last question. Can you refuse the showings of these properties? As realtors and as real estate licensees, no. We can never refuse to show them the property, but we can step out of the way. So let's say we were dating. And we pulled up a listing and the listing was not offering us any compensation. And when, or it, you know, 200 bucks or whatever. And so we could go back to the buyer and fully disclose if we're dating and say, I'm sorry, it's just not enough compensation for me. I will step out of the way and you can go work with someone else who wants to show you that property and is willing to, but that's just not enough for me. Okay. But I cannot refuse, right? And say, oh, that property's not available or that property, whatever. I mean, the DOJ has just torn that up. That's a bad thing. Don't do that. Now, let's say we're engaged Okay, we have an agreement. I'm never going to refuse to show them a property because either way, I'm getting paid. I'm getting paid by someone. But because of standard of practice 113, I'm going to disclose to them what the compensation is so that the buyer understands. The buyer knows they owe me 12%. Hey, by the way, this property is offering 0. Now the buyer can make the decision, not Cynthia. The buyer makes the decision what they want to do from there. So the buyer can decide if they want to see it. The buyer can decide if they don't want to see it. That's not my choice. That's with any property, right? Buyers decide if they want to see properties or don't want to see the properties. That's up to them. It may not fit their needs. It may not, whatever. But we don't get to make that choice. So I wanted to be clear about that. But if the buyer doesn't want to pay the overage, that may be one of the choices they make. Or again, they can ask you to negotiate it. They negotiate it with their offer. Okay. But with the bonuses, again, we figure out a way to kind of get that back to them. Basically, is what we're gonna do. So, should all the agreements of what property the buyer decides to see be documented for our records? And should the terms of what buyers offer or request to be documented separately from the offer to delineate who is making the request? Yes, and this really should have been done all along. You should always log what you're showing and what you're not, and what, why, and whatever. So absolutely, because if you ever have a complaint for fair housing, I was expert witness in a fair housing case. You better be logging all that stuff because all you need is one person to claim you have a fair, you have mistreated them due to fair housing. You better have some type of protection. So yeah, you need to document what you're showing and all of that for sure. And yeah, it's absolutely. And a lot of our MLSs can help us track that stuff. We have a lot of great tools, with technology and so on. But yeah, absolutely. You want to make sure that you're documenting what you're showing them. And our state, DBPR, the Division of Real Estate, has some expectations if they come in and do audits of your files as well. So you definitely want to make sure that you're tracking that. So who is tracking or regulating these agreements prior to closing? Again, that's all part of our first of all, your broker should be, but then from there, the Division of Real Estate prior to that. But if it's specific to the buyer, maybe that question, I'm just trying to elaborate a little bit and kind of think about what more could be in that question. If it's more about the buyer doing what they're supposed to do, who tracks the seller doing what they're supposed to do, right? And if they don't, that's the broker's choice to enforce the agreement or not. So, okay. Okay, so questions about timing. If you start the agreement before July, but then it closes after all of this kicks in, from what I understand from the Florida Realtors webinar, and again, there's a lot of clarification trying to come on this, but you do not have to go out and get all new agreements signed when the rule changes take place, okay? So we just kind of keep moving forward. It's almost like when a new contract form comes out or things like that, we just start using the new forms and we just kind of close out those old forms and keep moving along and getting that stuff closed. So it's not necessarily that you have to do anything different. You're going to use what we have now. And then as the new documents come out, we'll get used to those and then we'll start using those. And then the old ones will close and we'll file those away, right? But everything is good. So, okay. All right. Okay. Can I address why I think agents advise sellers? Whoa. Okay. Let me clarify that. That is not what I think. Okay. Let me rephrase this question. Why do agents advise sellers to offer different compensation amounts for no brokerage relationships versus transaction brokerage versus single agency? I can't speak for other brokerages and other agents. I really don't know. But what I would say is I hope that everybody has a clarity of what the agency relationships are, what the brokerage relationships are. They're not agency relationships, what brokerage relationships are, and what it means. So a lot of people have a huge misunderstanding of what a no brokerage relationship is. And I had mentioned that I've used these exclusive buyer brokerage agreements a lot in a no brokerage relationship. So let me just expand on that a little bit to share, and maybe it would give more clarity for you. But whenever there is someone in the transaction that has a higher level of a relationship, right? Particularly with a fiduciary, it strips that relationship from any licensee, me, right? And takes it to a higher level. Let me give you an example. When there's an attorney representation giving a fiduciary to a buyer. So there's an attorney that has been hired to represent a buyer in a transaction, not closing at a title company that's owned by an attorney. There's no representation there. But when the attorney is hired to actually look over the transaction and give them legal guidance, I actually love that, because when the attorney is in the transaction, it really reduces your liability. But so I work a lot with attorneys. Anytime there's an attorney in the transaction, they take on that relationship, that legal representation of that fiduciary, and you now are no brokerage. Anytime I sell a house to an attorney, they want to represent themselves. They go, yeah, thanks anyways, but I'm going to give myself my own legal representation. So they want to sign a no brokerage relationship with me. And I've been instructed before by attorneys to have to call and negotiate commissions because, maybe it wasn't to satisfy the agreement. And so I've been through this before. This is nothing new to me. I've done this for years. So the, just a clarity and an understanding. Some people think that no brokerage relationship is when the buyer is representing themselves with no realtor or no licensee, and that's not the case. That's not at all what it is. It's a form in our Brokerage Relationship Act, so it's an option. So maybe that helps giving some clarity there. So, okay. You mentioned that the buyer can decide not to see a property if they're not offering to pay the buyer's side of compensation. How do you know if the seller is going to offer that if it's not viewable? Call the agent. Does the seller have to offer the same thing to each offer? Ooh, good question. Okay. So yeah, we would, moving forward, let's say post-settlement, that's probably going to be call the agent and get clarity. Now, let's talk about as a listing agent, and this has already been brought up in several platforms. Is the seller going to have to offer the same thing, the same compensation amounts to everyone as far as based on your brokerage relationship, similar to what it is now? Well, let's talk about the opposite of that. What if they don't? Could that be viewed as a fair housing violation? That they're offering 12% to this person and 2% to this person and 18% to this person, and that could get pretty ugly. So that's kind of been the talk. So Florida Realtors is working on a compensation form that we'll clarify. It will be signed, and it will be something that can just be shared. So we can email it out or whatever. I don't know what it looks like. It's not created yet. They're working on it, but we'll have something available so that we'll have something to share and make it available. But I would highly encourage you to call the legal hotline before you start offering different compensations for different people. That could get a little sticky. So what would be a professional explanation to a buyer that sees that some sellers offer compensation for buyer's agents and other sellers don't offer buyer's agents compensation? Basically that it's, all compensation is negotiable. Maybe go back to the realestatecommissionfacts.com website that I mentioned and sharing that, because there's some good stats and numbers on there. But basically that, there's just a lot of different scenarios that can come up, and it's really up to each individual seller what they offer, if they choose to offer anything, and so on and so forth. Okay. So that is really the answer there. So, okay, let's dive back in then. I'm going to show you some more things in the Code of Ethics. And then again, I want to make sure we're clear in some of these scenarios with the compensation, right? And the way that the compensation works itself out. All right. So we went through, let me go back and make sure that you're looking at the Code of Ethics screen. I really want to go through Article 16, because that's where a lot of the things take place once you are actually engaged, right? Once you get engaged. So we read Article 16 already, that's, you don't want to interfere in any type of exclusive relationship that already exists. So that's why we ask the question, are you in an exclusive relationship or are you exclusively represented? That probably sounds better. Are you exclusively represented by a another realtor, another brokerage, right? Okay, so that's Article 16. Now I'm going to pop up here on the other column to Standard of Practice 16.3, that what it says is that this does not preclude realtors from contacting the client of another broker for the purpose of offering to provide or entering into a contract to provide a different type of real estate service unrelated to the type of service currently provided. And this is what I mentioned that, now they're talking about maybe property management as opposed to brokerage, but it might also be a duplex as compared to that waterfront luxury primary residence, right? Or from offering the same type of service for property not subject to the other broker's exclusive agreements, which is Tampa to Jacksonville to Titusville or whatnot. However, information received through a multiple listing service or any other offer of cooperation may not be used to target clients of other realtors to whom such offers to provide services may be made, right? Clients, again, because they've hired us. So basically it's okay to have two agreements or in two different markets or, two different types of services. That's okay. And that's acceptable per the code of ethics. Okay. Now moving down to 16.5, realtors shall not solicit buyer agreements from buyers who are subject to an exclusive buyer agreement. However, if asked by a realtor, the broker refuses to disclose the expiration date of the exclusive buyer agreement, the realtor may contact the buyer to secure such information and may discuss the terms upon which the realtor might enter into a future buyer agreement, or alternatively may enter into a buyer agreement to become effective upon the expiration of the current one, right? The current exclusive agreement. This is the same thing that the listing is 16.4. So this is the same thing that we have with the listing agreement. This one's for the buyer's agreement. Now, let's say that the buyer has an agreement in effect, let's say that goes till April 15th, okay? And you can sign an agreement with you're in a different company that starts April 16th and there's no conflict. That's what that last sentence talks about. Alternatively, they can enter into that new buyer agreement that becomes effective after the expiration of that prior one. Now, 16.6, when realtors are contacted by the client of another realtor regarding the creation of an exclusive relationship to provide the same type of service, and realtors have not directly or indirectly initiated those discussions. You are not the one trying to create this conversation, but they have contacted you. Okay, they initiated it. They may discuss the terms upon which they may enter into future agreements, or alternatively may enter into an agreement which becomes effective upon expiration of any existing exclusive agreement. This is for both buyers and listings. Okay. So if they call you and they say, hey, our agreement expires next week and we're searching around for a new buyer representative, we want to consider you, right? You can talk with them because they initiated the conversation, but you can't go poach other people's clients, okay? You can't call them and go, hey, what's going on? I see you've been working with them a while and I want to help you. You can't do that, okay? They call you though and say, hey, we're thinking of making a change. Can you come talk to us about that? That's acceptable as long as they initiated that, okay? And then 16.7, the fact that a prospect has retained a realtor as an exclusive representative or an exclusive broker in one or more past transactions does not mean that you own them forever, okay? It doesn't mean that you preclude the other realtors from seeking their future business. They're free to hire whoever they want, whenever they want, okay? You don't own them forever. Okay, 16.10, I think we already went to, we went through this. So you have to disclose the relationship and then follow that up with a written confirmation. And we went through 16.11 on the unlisted property with that. All right, 16.14, realtors are free to enter into contractual relationships or to negotiate with sellers, buyers, or others who are not subject to an exclusive agreement, but shall not knowingly obligate them to pay more than one commission, except with their informed consent. So there was a question early on, there were several questions actually about how do we know? And again, Article 16 says we're going to ask, we want to make sure we don't interfere. And the only way we can do that really is by asking. So we ask and we hope that they tell us the truth. And then if you pick up on some things that go, wait a minute, something doesn't seem right. What do you mean you already saw this property? What do you mean you know about this one? How do you know? Right? You need to ask some more questions. And once you realize they've already been, they've already signed another agreement with someone else, you need to go, wait a minute, this isn't how this works, right? Maybe they didn't understand what they were signing. It wasn't clarified to them really well, whatever. You need to make sure you stop and you have those conversations, because what happens is when there's one buyer and there's one closing, which means there's one pot of gold, but there's two brokerage companies that both feel they're owed the money, that's what we call an arbitration, right? And that's Article 17. That's an arbitration hearing, which is who gets the money. And we want to try to avoid that. If you can find out in advance, ask questions in advance and try to avoid that as much as possible. All right, Article 1616 standard practice. This is my last one for you. So realtors, when we're acting as a buyer's representative, shall not use the terms of an offer, I already went through this, to purchase, to modify the listing broker's offer of compensation. So again, realtors can't do that, but the buyer can put that in their offer and make that negotiation. Okay, so the buyer can freely do that with whatever and whenever they want in their offer as part of the negotiations, as we've talked about some of these different scenarios basically that come up. Okay, so again, let me kind of reiterate the compensation. Okay, if the agreement says 12%, okay, we have to find out. All right. So pre-settlement going into effect, pre-rule change. Let me say that pre-rule change sometime in July, right? You look in the MLS, you see what the compensation is. Let's say, for example purposes, it's $200, right? You declare that to the buyer, because remember, standard practice 113, I'm going to tell them what compensation is being offset. And I'm saying, hey, this one's paying $250. What do you want to do? Now, they may go, well, what are my options? Well, we can choose to see the property. And if you like it, you can ask as part of your negotiations that the seller pay my additional compensation. If they refuse, you could pay it, or you could choose not to see this property if you're just not sure, and we can move on and find something else. So the buyer can make those decisions. And then based on what decision the buyer makes is based on what the outcome, right? If they like the property and they want to make an offer and move forward, they may look at the property and not like it. So may not be an issue, but that's if it's less. If it's equal, hey, life's good, right? We close the deal, we get paid the 12%, it goes on the closing statement and we're good. But if it's more than that, post-settlement, post-rule change, we don't accept the overage. And so there again, we figure out how do we get that back in the buyer's hands or negotiate that back into the deal, right? Because we rebate that back to the buyer is the best way to put it, in whatever form or fashion, basically that we do. Okay. All right. So question comes up, what about price? What if they ultimately buy something that's outside of the price range that's in the agreement? Is it still enforceable? I'm going to guide you to call the legal hotline on that one, because that is more of a legal question of an enforceability of the contract. So I'm going to tell you to call the legal hotline on that. Okay. What if we have a buyer's agreement for 3 months, but the buyer never finds anything? Can I charge a fee for the 3 months? Well, that's why the agreement has a retainer section in it, up to you. And that's a business practice that you can discuss with your broker, basically. In the state of Florida, does a buyer have to be a husband and wife, or can one or the other sign? So in Florida, even if you are spouses, married, let's just call them married spouses, even if you're married, you do not have to have your spouse to buy property. Now, I say that with a caveat, because even if you buy your property without your spouse, if you are buying it with the intent to reside in the property as your primary residence, the spouse will need to come and execute the mortgage. They won't be responsible for the note, but they will be required to execute the mortgage at closing. But if I'm paying cash for property, I don't need my spouse ever, if I'm only going to put it in my name, and things like that. So no, not necessarily. And we see that with investment property sometimes makes for a happy marriage. So if you have your own properties, confirmation from or to the listing broker regarding the buyer representation. Does the buyer agent have to disclose the amount the buyer has agreed to pay? No. The code of ethics does not say you have to disclose the amount they're going to pay. The only time that would come up is if it doesn't match and the buyer is asking to negotiate that in the contract. So again, that's when it may come up where the buyer is now putting into the face of the contract that they're asking the seller to pay 12% compensation to the buyer's representative to satisfy the exclusive buyer brokerage agreement. Only then would it come up because they're negotiating that as part of the transaction, as part of the fees and the expenses, right? So from there. So can we advertise the co-broke on social media? There's no restrictions in the settlement. The only restriction in the settlement is for the MLS. So yes, you could advertise that on social media if you chose to do that. The only restriction is for the MLS. There will be no mention of the compensation, the co-broke in the MLS, and there cannot be anything linked to compensation. So what I mean by that is if the seller is giving buyer closing cost, they cannot restrict the buyer to only use that closing cost to pay the buyer's representative fee. So if the seller is offering 12%, and it's just an example number, I understand the lender's not going to allow that. But if the seller is offering 12% of closing costs to the buyer can use that for whatever they want. They don't have to use that to pay their buyer rep fee. So they cannot restrict them to only use that to pay the buyer rep fee. You cannot put that in the MLS. Those terms of conditions cannot be in there. Okay. And showing time. Is showing time a part of the MLS? What can you or can you not put in that app called showing time? You're going to see more clarification coming out on this, but is showing time in the MLS? Yes, there will be no compensation discussed in that. So you're going to have to pick up the phone and call or talk to somebody or go outside of the multiple listing service, period. That's just the way it's going to be. And so let me just say this. It's going to be okay. We are going to get through this, right? I know that this seems like a catastrophic change happening right now, but we have been through major changes before in our industry, and we will get through this and we will figure this out and we will come through better on the other end. So if we have to pick up the phone and call each other or send a text to say, hey, are you offering any co-broke compensation? So be it. We send a text and we ask and we get the answer. And then we notify our buyer if we're engaged, right? Which we're going to be engaged, and tell them, and then they make the decision of what they want to do from there. That's going to be the process. And it's going to be okay, right? Trust me, I've been doing this process for a very long time, right? It's going to be okay. So the only difference is we're not going to see it immediately in the multiple listing service, what that co-broke is, but it's going to be there still, just not so clearly in the MLS. We will communicate that to each other. We'll just communicate. That's what we'll do. So it's going to be okay. We will get through this. We'll be fine. So, okay. I want to wrap this up. The rest of the, your forms, there's a couple of things in your materials that I do just want to kind of, jump to, which is on page 25. And I want to bring to your attention, in Florida, we have this new law about foreign buyers. I have put it into practice to talk to all of my buyers about this at the buyer meeting, right? In the beginning, the buyer consultation. When I sit down with the buyer, I say, by the way, Florida has this law that went into effect July 1st of 2023. And I just want you to be aware of it. And I give them a copy of the Florida affidavit. There's a FREC affidavit that all buyers must now acknowledge at closing. So I don't know which buyer is going to be affected by it or not. So I've just put into practice recently that I'm talking about it to all buyers and I'm giving them all the affidavit. And if they have a concern or they think that it may affect them, then they need to go speak to a real estate attorney. All right. So that is something you want to be aware of. On page 25, this is the foreign buyers that they come from. And there's a list here of the foreign countries of concern. It's there for you on page 25 that if they are from one of these foreign countries of concern, there's limitations Doesn't mean they can't buy, but there are limitations to what they can buy and where those properties are geographically located. And that's why they need a real estate attorney to kind of help them through that process. Okay. And then, yeah, we've talked about that I think we've gotten through all of that. So questions. Let's see. We've I thank you guys for your patience. There are a lot of us here. So I appreciate the fact that, you guys jumped in and you signed up quick because this class split up very, very quickly. And that you were able to come and to sign on. There's just a couple other things noted here for you in the materials, page 18 through 21, that just talks about some of our sign laws of advertisements and so on and so forth. You might just go reference from that. Let me just see other questions basically
There
popping.
are, Cynthia, if you want me to summarize a couple of things that I know people have been asking for a little review on, I know you did go over them. A couple of them were due with, can addendums be made? Can the BBA be changed? If you're middle of the process and you want to change things, how do you handle that?
Okay. So currently there is no addendum to the exclusive buyer brokerage agreement. So in that effect, if you need to go back and make changes, or if you need, let's say the one is expiring and you want to start a new one, you just sign a whole new agreement. If you need to make massive changes to it, just cancel it and start over with a new one, is basically what's being recommended right now. So that you may see change, but that is the process now. So if you're not happy with some of the terms, or the buyer's not happy with some of the terms or something like that, you just move forward to a new agreement, basically, because the termination is open for both parties to do at any time at that fact. So let me look at a couple more. So what if, okay, so if the seller, so this is a great question. What if the seller is offering 11%? Okay, I'm going to paraphrase your question a little bit differently. But if the seller is offering 11% and your agreement says 12%, can your broker agree to forgo that 1% difference and not go after the buyer for that? Yes, they can. And that's kind of where that range commission pricing comes in. The only thing is, be careful, because if you're doing that for one and you don't do that for the next buyer that comes along, what does that look like from the outside? So you have to be very careful that that doesn't look like a fair housing concern or violation, right? Those are some of the concerns that you just want to be prepared for. So be very, very careful with that. And I think everything else. So the FREC affidavit, you can get that. Actually, I think Florida Realtors had it on their website for quite a while, but you could probably Google search that and find it, because I don't have that form open, so I'm sorry. But so there is no cancellation form right now for the exclusive buyer brokerage agreement. It's just a written notice is what it calls for. So, okay. I think we've gone through just about as much as possible. Thank you guys.
I
again.
sure hope so.
I just wanted
all
to,
right.
this is Sharon, by the way, you guys, thank you all so much for today, for your patience. We have answered over 900 questions and still have about 100 that are coming in. I am doing my best to try and capture those and see if we can't get them answered for you. So thank you all so much.
We do get a report afterwards of all of your questions, and we do have a bunch of the questions in and all of that. I can message some of these to Cynthia. But again, a ton of information was gone over today. We do have a couple of other ones upcoming. If you do feel like you want a refresher or some more information, you can go ahead and take a look at our classes that we do have upcoming as well. But aside from that, we are going to be closing in just a few minutes. We have gone through everything. You've done your time. So thank you once again to Cynthia for being with us. If you do have any last minute questions that you feel like you just absolutely have to get in right this second, we do have that Q&A still open, and we are capturing those as they come in. So thank you once again for being with us. I do see a couple of things in the chat. No, you do not need to leave us your name or your license number, or I'm sorry, not the chat, the Q&A. You do not need to leave us your name, your license number, your email, none of that stuff. When you registered, you did give us all of that information. So if you did use the link that you were sent to join Zoom today, we will be getting all of the information you provided for us. So please, please do not leave us any of your license information or your emails in the Q&A so we can make sure that we are focusing on those content questions. We have not recorded today's class. It is not a recorded class. So no, we will not be sending out a recording. I will say we are going to close down at 11:55. So we are going to close at 11:55.